Well, good afternoon, friends. Let's start now with this session. We have a couple of speakers for this afternoon, and we don't have much time. We have about 1 hour and a few minutes, and therefore, let's start. Our discussion is, of course, on policy what is it? Not a policy recommendation. This is on managing the tension and the future of the South China Sea. I was joking today, tension and the future of South China Sea is like what we had yesterday. We had a typhoon, and now we hope to have the sun today. And I hope also the South China Sea, the typhoon has passed away. Now we are looking for the sun coming up in the South China Sea area. And for that matter, we should start with Mr. VELASCO, who will give us his impression about the South China Sea. Please, Mr. VELASCO.
Thank you, Mr. Chair. Thank you to the Diplomatic Academy of Vietnam and the Vietnam Lawyers Association for this opportunity to speak. Implements, or more broadly, their raison d'etre, which is what this presentation is all about. We could consider 3 general or correlated elements or factors that make confidence-building measures and tension de-escalation as effective tools in conflict resolution and dispute settlement. They could loosely be categorized into objective, subjective, and temporal elements. Objective element. Confidence-building measures are means to an end and not the end themselves. They serve as processes towards a definite end product, which in the South China Sea milieu is the peaceful settlement of disputes in accordance with international law. This is true in all other settings where conflict or dispute is involved. In peace negotiations, for example, of which I have an experience, confidence-building measures such as ceasefire and joint monitoring mechanisms are not the end product. They are instead the means or tools or necessary processes towards achieving a final peace agreement. It is important to keep this in mind because if one confuses the role of confidence-building measures by making it the end instead of the means, then a conflict resolution process is doomed from the start. Under UNCLOS, the peaceful settlement of disputes is imperative. We can actually say this to be true in any other dispute, given the dictates of the dispute settlement provisions in the UN Charter. Thus, when we speak of confidence-building measures or tension de-escalation in maritime space, such as the South China Sea, they are inevitably attached to the notion of peaceful settlement of disputes. They exist for a greater purpose, which is to set the environment for achieving the ultimate objective, to end a lingering conflict. UNCLOS does not specifically mention the terms confidence-building or tension de-escalation, but these ideas are deeply embedded in its provisions. For example, Articles 73 and 83 regarding the obligation of states to delimit their overlapping EEZ and continental shelves, there is a common provision providing for provisional arrangements. These provisional arrangements of practical nature are by their very nature confidence-building measures pending final agreement. By the clear import of the language used, they are not the end goal. They are a mere transitory phase as they are without prejudice to the final product. These measures, while desirable, cannot be pursued at the expense of the final product itself. Confidence-building measures should not have a different value, or worse, accorded higher value than the resolution of the conflict itself. This framework is important if we are to interpret instruments whose purpose is to find ways to resolve conflicts, such as the 2002 Declaration of Conduct. Let's take, for example, operative paragraphs 4 to 6 of the DOC. Paragraph 4 of the DOC pertains to the undertaking of the parties to resolve their territorial and jurisdictional disputes by peaceful means. Paragraphs 5 and 6 enumerate confidence-building measures pending the final settlement of the disputes. Following my discussion, therefore, cooperative activities such as marine scientific research, marine environmental protection, and even joint exploration or joint development, while definitely are worthy endeavors, should not be used to undermine or downplay legitimate means of resolving disputes. For the Philippines, arbitration and cooperative measures are not mutually exclusive, but some parties demand that the Philippines drop arbitration and proceed with cooperative measures. This does not seem to be a correct understanding of what confidence-building measure is. The message is really simple. Confidence-building measures, when undertaken, should not ignore, much more replace the real end goal, the peaceful settlement of disputes. Subjective element. The second element is closely connected with the first one. It delves into the intention and motives of the parties involved in the dispute. By obvious linguistic coincidence, confidence building implicates the intention and desire to build goodwill among the parties, and tension de-escalation presupposes the desirability of establishing or re-establishing good relations. At the very core of all this is the basic notion of good faith. Good faith is a fundamental principle in international law and international relations. In the words of the ICJ in the nuclear test case, one of the basic principles governing the creation and performance of legal obligations is the principle of good faith. Trust and confidence are inherent in international cooperation. This is also the underpinning principle of dispute settlement in UNCLOS, as enunciated in the preamble. The genuine intention of the parties involved to resolve their disputes is crucial. Any measure to build confidence or de-escalate tension should have no other agenda but to ease the situation and contribute to the resolution of conflicts. If provisional arrangements are used as subterfuge to perpetuate and adjust status quo or create a new one, then they do not contribute to conflict resolution. If they are pursued to take advantage of the vulnerabilities of the parties for the purpose of creating or furthering a condition that is contrary to the dictates of international law, then obviously they are not worthy endeavors of the international community. What is unlawful cannot be legitimized by any confidence-building measure. Thus, a joint development agreement that would legitimize an excessive maritime claim does not simply build trust and confidence. And because measures to build confidence and ease tensions are mere transitory phase towards achieving the end goal of peacefully resolving disputes, undertaking these measures is akin to or even forms part of a greater duty to negotiate in good faith. Part of the duty to negotiate in good faith is showing flexibility in one's position, having due regard to the lawful interests of the other party, as rightly put by the ICJ in Macedonia v. Greece. The ability to be flexible in negotiations proceeds from the strength and clarity of one's position. An authentic confidence-building measure should provide space for dialogue and an opportunity for parties to clarify and convince one another about their position to a dispute. It should allow or encourage them to define under what legal basis do they advance their claims, and from that, negotiate for a mutually acceptable solution. It could not be a tool or opportunity to perpetuate an ambiguous position, which only breeds more misunderstanding and mistrust, and thus defeats the very purpose of confidence building. Only with clarity can one have flexibility to negotiate in good faith. As you can see, if we clarify which area are disputed, then we will know what it is that we should be negotiating. Corollary to the duty to negotiate in good faith is the duty to execute in good faith any arrangement, including those agreed upon as interim measure to de-escalate tension. For example, if parties agree to withdraw from a disputed feature, the failure of either of them to comply with the agreement runs counter to the notion of good faith and renders useless the very essence of confidence-building measure and tension de-escalation. Case in point, Scarborough Shoal. The Philippines and China agreed to withdraw their vessels around the shoal as a way of easing the tension. Until now, only one party has complied with that agreement. Creativity is the only limit to creating conditions for resolving conflicts. A lot of these ultimately depend on the will of the parties and on the bona fides expected from them by international standards and norms that favor the peaceful resolution of disputes. Indeed, a modus vivendi cannot be used as somebody's modus operandi to aggressively advance one's position in a dispute. The last element that ought to be stressed is that confidence-building measures and tension de-escalation efforts are intended to be time-bound insofar as the parties are expected to settle peacefully their disputes. There couldn't be confidence-building measures ad infinitum, Otherwise, the term confidence building would become an oxymoron. Going back to the example of peace negotiations, there couldn't be an unending ceasefire if the true objective is to finally end an armed conflict. In the same manner, there couldn't be cooperative measures in perpetuity if the intention is to resolve territorial and jurisdictional disputes. If we do not acknowledge the temporal nature of confidence-building measures, then we could be led into thinking that provisional measures are the best and final and only arrangements that we could get. A confidence-building measure, therefore, if intended by one party to be a permanent solution, will not contribute to the peaceful resolution of disputes. To be clear, we are not cynical about confidence-building measures. We do acknowledge their inherent value. We are neither being overly idealist about it. In a way, there is a sense of realism when we prod everyone to ask, what are the intentions of the parties for engaging in such measures? Is it, for example, to isolate the Philippines in order to force it to backtrack from arbitration, which admittedly is a peaceful means of settling disputes? If yes, what is the political and moral value in that? The Philippines initiated the arbitration against China because it does not have the economic and military ability to stand up to it. But there's one hope for the Philippines, and that is the rule of law, which it so vociferously pursues under the banners, right is might, and law as the great equalizer. Rule of law entails clarifying the maritime entitlements of the parties under UNCLOS. Rule of law means adhering to the dispute settlement mechanisms prescribed in and inherent within UNCLOS itself. It is this basic rubric of rule of law that the Philippines sees the value of confidence-building measures. If contrary to their true nature, these measures do not contribute to the peaceful settlement of disputes and instead serve to prolong the conflict, then they do not contribute to the rule of law. The Philippines believes that the rule of law is a value that should be pursued now more than ever by the international community, not just in the law of the sea, but in all other aspects. For example, climate change. And sorry for the digression, but I have to say this because of what happened in the Philippines with Typhoon Haiyan. In the greater scheme of things, measures to build confidence or de-escalate tension should contribute to the creation of a world public order that rests in the rule of law. Thank you.
Thank you, Chairman. And although the time is limited, but I can't start my presentation without thanking the organizer. Thanks for the invitation. And these 2 days we talked about typhoon. What I get from the typhoon is I see the power of nature and the weakness of human being. For me, we should respect the nature and live with nature in harmony. And also, from this disaster, we could hope that people in this region could be connected and cooperate. With this, I come to my presentation. The outline of my presentation is as shown on the slide. Since 2009, although the disputes in the South China Sea are in general under control, the developments shows that China-Vietnam and China-Philippines are two key relationships that have experienced incidents leading to fluctuating levels of tension in the South China Sea region. China-Vietnam and China-Philippines respectively have made efforts to handle both incidents and tensions through various approaches. The intention of my research is to review how these two bilateral relations evolve in relation to the South China Sea issue, with the focus on the post-2009 period, and to try to shed some light on the future. After the introduction is the overview of the developments, followed by analysis of the approaches utilized. In the concluding, I offer some initial observations. Since full normalization of relations in late 1991, tension in China-Vietnam relations has primarily been caused by differences relating to territorial disputes. They include overlapping claims to the Paracel and Spratly Islands, to water and continental shelf areas in the South China Sea and in the Gulf of Tonkin, and to areas along the land border. Through the 1990s, until the end of 2000, the pattern of interaction is negotiation parallel with periods of tension. Breakthrough happened in 1999 and 2000. That is, a land border treaty signed on 30th December 1990, and also the other agreement on the delimitation of territorial sea, exclusive economic zone, and continental shelves in the Gulf of Tonkin, which is signed on 25th December 2000. From 1992 to 2008, this pattern of interaction relating to the disputes in the South China Sea continued to prevail with continued dialogue and only limited periods of tension caused by the disputes in the area, mostly focusing on the cases of oil exploration and fishing. Differences between China and Vietnam increased in 2009. Two submissions in May drew China's protests. I will not go detail. You could read in my paper. And also open differences relating to activities in the South China Sea continued during the first half of 2011. And most serious incidents occurred in late May and early June. And during these periods of tension, the two countries also took actions to reduce the level of tension. In June 2011, during the visit to China by a special envoy from Vietnam, an agreement was reached to speed up negotiations on agreement on basic principles, guiding the settlement of sea issues between the two countries. And two significant developments took place in October 2011. The agreement on basic principles was signed in October, and also the first high-level summit between the two countries since 2008 took place also in October when Vietnamese Party Secretary visited China. 2012 also saw intensive talks between the two countries, including negotiation on sea area beyond the mouth of the Gulf of Tonkin, and also working group talks on cooperation on less sensitive fields at sea. This trend continues in 2012, and some concrete results are achieved in both talks. Regarding the first one, both sides proposed positions in more details on relevant issues relating maritime delimitation. Agreement was reached on strengthening negotiation over the issue of joint cooperation in the said area. A group of technical experts will be formed to carry out joint survey. In regard to the second, the working group talks on cooperation on less sensitive fields at sea. Both sides agreed to going through relevant procedure to sign agreements. So by the end of this year, two projects which are discussed could be started. And also two high-level exchanges of visits also happened in this year. The first happened in June when the Vietnamese president paid a state visit to China, and also in October when Chinese Prime Minister visited here. And also two hotlines have been established between both foreign ministries and both agriculture ministries from the two countries. And in regard to the development between China and the Philippines, since diplomatic relations were established in 1975, the China-Philippines relationship was in general developing smoothly. The year of 2009 witnessed the start of potential increase of tension in our bilateral relations in regard to the South China Sea. This tendency is reflected from bilateral spat over several cases. They include legal spat over maritime claims. The first case is around 2009 about the 2009 baseline law by the Philippines. And the second one is undergoing a Philippine arbitration case against China, which was initiated this January. And many experts have touched about it during this workshop. The second is spat over resources exploration, in particular over early 1211, the oil exploration around related claims. And the other one is spread over some insular features. The first one is Scarborough Shoal in April-June 2012, which my Philippines colleague just mentioned, and the second one has happened in May this year over Second Thomas Shoal. About their approaches in managing their bilateral disputes, regarding to China-Vietnam, in order to manage their territorial disputes, both countries initiated a system of talks and discussions which are both highly structured and extensive. They include from bottom to top expert-level talks, government-level talks, foreign minister-level talks, and also high-level talks. Thus refers to talks between presidents, prime ministers, secretary generals of the communist parties of both countries. And in 2012, since 2012, some new initiatives also created. They include what I just mentioned, the 2 hotlines. And since 2005, there are also 2 more mechanisms of talks have been formed. They do not directly deal with territorial issues, but they work to create good environment for future discussion on thorny issues of territorial disputes. The first one is China-Vietnam Defense and Security Consultation Mechanism, started in 2005 and headed by Vice Defense Minister level 8 generals from both countries. The second is a series of talks of China-Vietnam Steering Committee for Bilateral Cooperation. That is started in 2006 and headed by Prime Minister level officials. And in regard to China-Philippine approach, after the mischief incident in 1995, both countries held talks leading to an 8-point code of conduct in the joint statement in August 1995. And also in 1996, in a joint press release, both countries agreed to set up bilateral consultation mechanisms, including 3 working groups in charge of fishery, marine environmental protection, and confidence building, respectively. However, these mechanisms are not effectively utilized, and post-2009 developments have shown that both countries took to ad hoc mechanism to deal with their tension. One example is during the case of during the Scarborough Shoal incident. New approach has been taken by the Philippines. One particular case is the unilateral arbitration case against China. So, what's the conclusion? The first observation is China and Vietnam have developed extensive mechanism for managing differences in the South China Sea. For China and Philippines, they have not developed such mechanism for managing their differences in the South China Sea. These basic differences can help explain the way in which tensions has been addressed in recent years. Despite progress continued, efforts are needed between China and Vietnam. And also, China and the Philippines need to establish better mechanisms to address their differences. In the end, all the 3 parties can positively contribute to regional efforts and to the China-ASEAN dialogue on the South China Sea. With this, I end my presentation. Thank you.
Good afternoon. My presentation will focus on the code of conduct, and we heard about this issue several times during this conference, especially in previous section. And my main focus is on ongoing process towards the COC consultation. And second issue is try to prognose possible elements of the ASEAN-China COC. And one of the most important elements of the future COC is elements regarding to prevention and management of incident in the South China Sea. So the third part of my presentation will focus on suggestion for preventing and managing incident in the South China Sea. So we all know that in September this year, China and ASEAN for the first time held official consultation on the code of conduct in the South China Sea. And this is a long road to begin. If you remember in 2002 declaration of code of conduct, in provision 10, party reaffirmed to work towards the adoption of COC. But it took almost 9 years for completion, just symbolic guidelines of DOC implementation. And in July 2011, then Chinese foreign minister said China open for discussion of COC when conditions are ripe. But he did not explain the condition are ripe is when is condition ripe. To take initiative, ASEAN held several rounds of discussion to discuss about proposed elements of the COC. And during 2012, ASEAN adopted proposed elements of China-ASEAN COC. And after that, after the incident in Phnom Penh, ASEAN adopted a 6-point principle. They call for early adoption, early conclusion of a COC. And in September 2012, Indonesia introduced a zero draft of the COC. And now we see China agree for consultation on the COC. So what can explain China changing approach towards the COC? There are at least 3 explanations. First, as I mentioned, as I discussed in last year's workshop, I observed that China approach towards the South China Sea became much more coordinated and centralized. So whenever China put the South China Sea into broader picture of its foreign policy, so it has to take care of interest in relation with ASEAN, with US, than just specific maritime interest in the South China Sea. So China will moderate its approach. So we see in this year, China seems to be more moderated in the towards ASEAN with new diplomatic and charm offensive towards almost all members of ASEAN, except Philippines, of course. So the COC changing approach is framed within this grand strategy of China of new chapter offensive. Second is explanation provided by US scholar James Holmes when he observed that China agreed for COC negotiation or signing so that China can get consent from ASEAN of new status quo. This means that ASEAN accepts for China new occupation in Scarborough Shoal. It's similar to situation with DOC negotiation in 1995-1998 after the mischief incidents. And the third explanation is possible that China calculation was influenced by Philippines' action to bring China towards arbitration. So for China, a less legally binding COC, of course, is more comfortable than a legally binding award of international arbitration, according to UNCLOS that China already ratified. Whatever China, even China decline and will not participate in the arbitration. From legal point, of course, we have a lot of legal experts here. The decision of the arbitration will be binding for China. For ASEAN, the next 3 and 4 years is very critical periods for ASEAN. Because if the arbitration decides that they have jurisdiction, and if they make an award in favor of Philippines, partly or fully. It will encourage other ASEAN claimants to follow Philippines' practice, to seek more legally binding awards that can regulate China behavior in the South China Sea, than just concentrating a less legally binding code of conduct. And consequently, ASEAN claimants will likely prefer a legal channel than diplomatic channel through ASEAN. So it's going to affect the ASEAN role as the most important channel for managing the South China Sea issue. So, despite China and ASEAN agree for consultation, both sides have different approach towards the COC. And you can see in the table I summarized the differences in approach between China and ASEAN regarding the timelines, framework level, form of discussion, role of third party, and form of decision making. When ASEAN call for early conclusion, China prefers step by step. When ASEAN prefer ASEAN-China negotiation on COC, China says the COC is framed within DOC implementation, and especially China try to concentrate on cooperative activities. And the form of discussion, ASEAN prefer official negotiation, when China prefer expert level consultation first, and then maybe official consultation. And role of third party, ASEAN open for respect of COC from third party, when China blame interference from third party for stuck of COC before. And form of decision making, of course, both sides agree for consensus, but different interpretation. ASEAN consider consensus between ASEAN and China. China prefer consensus between parties. But at Suzhou meeting and foreign minister meeting between ASEAN and China this year, it seems that ASEAN agree almost with all the provision that China required. And ASEAN and China agree for for consultation and agree for establishing an expert group for discussing the COC. And the consequences, of course, China can use the consensus principle to veto or to delay the process. First on the expert level, and then they have a second barrier on the official level. So the conclusion, preliminary conclusion here is COC is a very protracted process. And second, and other issues, despite China and ASEAN agree for consultation process, but content is more important than process. And COC have to consider several issues. First is scope of application. Some people already mentioned yesterday, today. Whether COC will apply only for disputed land features and their maritime zones. Disputed land feature, of course, separately, and Vietnam would prefer paracel to be included in the COC, and China was opposed, of course. Philippines may protest to incorporate Scarborough Shoal to the COC because, as I mentioned, it's going to legalize China occupation there. But the second question is how big the disputed maritime zones. Is it applied for just territory seas or easy on continental shelf of the islands and rocks there? If some islands can generate easy and continental shelf. We know that ASEAN and China have different interpretation of islands here. So even they agree that COC can apply for easy of disputed land feature, the next question is how far the disputed maritime zones. Is it applied for the area beyond the equidistant lines between land feature and baseline of coastal states. Because it's overlapping area, it's the overlapping area between maritime zones of Separat Lake, Paracels, and EG generated from baseline of coastal states. And here's more important, if they want to apply for this disputed maritime area, they need to clarify what is disputed area. But to clarify what is disputed area is not business between ASEAN and China, but it needs negotiation and discussion between surrounding country or between claimant state. So maybe ASEAN and China will repeat the experience of DOC negotiation to apply for the whole South China Sea, and later each party can blame each other for violation and justify their action because ambiguous area of application. Second issue is whether COC is political document like DOC or legally binding document. Here's a dilemma for ASEAN to balance between a legally binding with insufficient consent and a political declaration with more detailed provisions. And of course, China will not agree with legally binding document with more specific detailed provisions. Just can constrain China from action in the South China Sea. And the third issue is relationship between DOC and COC. China and ASEAN almost agree with China in this beginning stage. Just COC consultation is framed within the DOC implementation. But if the COC incorporate own elements of the DOC, so no need more DOC. The COC will replace the DOC. But the most important one is objective of COC, or the content of the COC. On ASEAN proposed elements, ASEAN proposed a COC, a rule-based framework for managing the dispute, for regulating conduct party through CBM cooperative activities and management and prevention of dispute. Indonesia zero draft consider promoting confidence and preventing incidents and managing and resolving incidents in the South China Sea is the main objective of DOC. Of course, it's predictable here that China will concentrate on cooperative activity, while ASEAN will prefer discussion on preventing and managing the incident in the South China Sea. Because it is incident in the South China Sea that led ASEAN for calling for early conclusion of the COC. But if the COC cannot prevent incident from the South China Sea, there will be another call for COC version 2 whenever incident happen again. So the big question now is what elements of COC that could prevent and manage the incidents in the South China Sea. So my next session will make some suggestions how to avoid incident and manage the incident in the South China Sea. We should first identify who is players, who is parties, what kind of activities that can lead to the incident in the South China Sea. We have military vessels from own countries through the South China Sea. And competition for, second kind of players, law enforcement vessels, mainly from coastal states for enforcing the legislation and for protecting the sovereignty rights in the South China Sea. And of course, we have civilian vessels from fishing, oil and gas, exploration, marine scientific research, search and rescue, and of course, own ships from own countries in the world. So the incidents in the South China Sea, the first kind of incident is competition for jurisdiction and sovereignty rights in the area of overlapping claims regarding to fishing activity, oil and gas exploration, marine scientific research, law enforcement vessel, in the same area of overlapping claims that led to incidents in the past and maybe in the future. And here is some picture, some location that you already know, fishing activity incident. It's mainly on overlapping area of EEZ between China and Vietnam, between Taiwan and Philippines, or in the territory seas of disputed land feature. Here we have incidents around Paracels and incident around Scarborough. As a kind of incident relating to oil and gas exploration, and we here see a lot of some kind of incident between Vietnam and China, between Vietnam and Philippines, between China and Philippines, and between China and Malaysia also. There was some reports of prevention from China against the Philippines exploration. And the area of incidents mainly within the night lines. So my suggestion to prevent and manage this kind of incidents, of course, the optimistic option is first delimitation, second is joint development agreements, or we can apply both delimitation and joint development. We can apply the experience between Vietnam and China in the Gulf of Tonkin. But the more feasible option, including defining disputed area, proper treatment of fishermen, no threat or evil force toward fishing boats, and fishermen, no arrest and confiscation in disputed area, refraining from using military vessels for law enforcement, keeping safety distance, and my suggestion again is establish Coast Guard Forum for the South China Sea to manage this kind of incident because it's relating to issue of exercise jurisdiction. Second kind of incident happened here mainly between China and US regarding to military activity in EEZ. We have EP3 incident, impeccable incidents, and the possible incident in the future relating to military activity in EEZ and in disputed area also. So here's two kind of suggestion, optimistic option, of course. Parties can conclude an INC agreement or reach a consensus on law of the sea interpretation. But more feasible option is prior notification of military activity, hostile communication, dialogue and discussion, and establishment South China Sea Navy Forum for managing this issue. So, for conclusion, for COC protracted process, but COC will be useful and can turn the South China Sea from the sea of disputes, from the sea of tension into the sea of stability. Depend on whether COC can prevent and manage the incident in the South China Sea. But incident here, as I mentioned, involve vessel or player from China and ASEAN, but ASEAN is mainly from surrounding countries, not own countries. Of course, Laos will not have any vessel in the South China Sea. But also, not only vessel from China and ASEAN, but from other countries as well also have conduct activity in the South China Sea. So there would be this kind of incident. And my observation, incident when navigating mainly occurs by accidents. And incident relating to aforementioned area mainly occurs by intention. But accidents can be avoided by existing regulation, but intention can be avoided and managed by negotiation of new regulation, bilateral or multilateral, surrounding countries or with other countries. So my integrated suggestion is to conclude a multi-layer agreement on code of conduct. We can have a military activity agreement between China and the US. We can have a military activity in disputed area agreement between China and South China Sea claimant country, ASEAN claimant country, Vietnam, Philippines, Malaysia, Brunei. And we can have agreement regarding to exercise of jurisdiction and sovereignty rights regarding fishing, oil and gas, development, marine scientific research, and law enforcement between surrounding countries, including China, claimant country, plus Indonesia. And a combination, we can have a COC between China and ASEAN, and a broader COC, regarding to navigation, commerce, security, relating to other countries as well. Thank you very much.
Thank you, Mr. Toy. Next one is Dr. Ian Storr.
I'd like to start by thanking the DAV and the Vietnam Lawyers Association for inviting me once again to this very important question and for giving me the opportunity to have almost the last word in this conference. The topic that was assigned to me was very broad and essentially forward-looking. So I thought I might look out 10 years from now and ponder what we might be discussing at the 15th DAV workshop on the South China Sea, which will be held in Da Nang. I've never been to Da Nang, I'm just saying, in November 2023. How might the situation have developed by then? Will our mood be one of frustration and resignation, confidence and optimism, or alarm and trepidation? So I posit in my paper 3 alternative futures, each of which I assign a nautical theme. They are treading water, plain sailing, heading for the rocks, and my very worst case scenario, shipwreck. Well, plain sailing is essentially status quo. That is to say that the pattern of behavior that we've observed over the past several years continues for the foreseeable future. And I think we can say 3 things about the status quo. First of all, the action-reaction dynamic between the claimants will remain unchanged. The claimants, the primary players, China, Vietnam, and the Philippines, will endeavor to uphold their territorial claims, both rhetorically and through acts of administration, and also to protest the activities of the other claimants. I think that China's robust policy on maritime disputes will remain essentially unchanged, except perhaps for tactical changes now and again. China has sent out a very clear and consistent message on maritime disputes under President Xi Jinping, i.e. that China remains committed to peaceful development, but that it will not compromise its territorial and sovereignty claims and will react assertively to those countries that challenge those claims. I think what we've seen with Japan and the Philippines over the past year is proof of that policy. In keeping with recent trends, China may well take a more maximalist view of the 9-dashed line. This was spelled out in an academic article that was published in January this year, co-authored by Judge Gao, who's the Chinese judge on ITLOS. It's been mentioned several times already at this conference. I don't need to repeat the central quote. It's up there on the screen. That essentially China is not only claiming sovereignty over all the features within the 9-dashed line, but also historical rights within that line. I think this is a bit of a worrying trend, not only because the 9-dashed line is at odds with UNCLOS, but also because really the 9-dashed line stands in the way both of a resolution of this dispute and joint development of resources. In that sense, and I think many people in this room would agree with me, the 9-dashed line is really the crux of the South China Sea problem. And unless and until it is brought into line with existing international law or gotten rid of, then we won't be making much progress at all. I think the second thing that we can say about the status quo is that none of us are seriously predicting a major war in the South China Sea. Although, of course, the possibility of an accidental clash at sea, which escalates into a more serious political, military, and diplomatic crisis, can't be ruled out, especially in the absence of effective conflict management and crisis prevention mechanisms. That brings me to my third point, the DOC and COC process, of which we've heard a great deal of over the past 2 days. I think, as most of you are well aware, I'm not terribly optimistic about the DOC and COC process. I think it is process-driven rather than results-oriented. I wonder if any of the cooperative projects that are currently being discussed under the framework of the DOC, if they are put into effect, will actually have any impact on reducing tensions, as Carl Thayer was alluding to earlier. China's lack of enthusiasm for a code of conduct is manifest, and at the Suzhou meetings in September of this year, China essentially dictated the pace of those talks, and let me invoke another nautical term here, dead slow ahead. I think that China will seek to draw out the COC talks for as long as possible. And I suspect that the final product, 2 or 3 years down the line, perhaps in 2015, as my colleague Termsak was suggesting, that the final product will be largely symbolic in nature. So, status quo for the foreseeable future. But how long can it last? I think the status quo must have a limited shelf life. So the question is, what is the post-status quo situation? And for that, I think we can turn to 2 of the alternative futures which I discuss in my paper. Plain sailing is my best case scenario. That is, between now and 2023, the claimant states finally muster the political will to pursue a peaceful, negotiated, and equitable resolution of the dispute that is acceptable to all parties. Now, this could be done in 3 ways. The claimants could submit the dispute to the International Court of Justice. Secondly, and better yet, I think, they could sit down and resolve the issue of sovereignty amongst themselves and also delimit maritime boundaries and reach an agreement on how to share maritime resources. The third option is to put aside the sovereignty claims and engage in joint exploration of maritime resources. What are the prospects of plain sailing? I think, based on present trends, they are exceedingly dim right now. We've heard a lot. Well, China has ruled out taking the case to the ICJ and has, as we've heard the last few days, refused to participate in the case brought by the Philippines. Negotiated settlement is problematic because China favors a bilateral resolution. Also, its insistence that sovereignty is non-negotiable presents an almost insurmountable obstacle to negotiations. The idea of joint development has received something of a boost recently, as some of our presenters were saying. But again, the 9-dashed line complicates things because it is the view of some of the claimants, including the Philippines, that joint development can only take place in truly disputed areas, and we don't know where these areas are until China clarifies its claims. So the political will to pursue a legal or negotiated settlement is currently absent, but that doesn't mean it will always be so. It could be that the claimants could be shocked into pursuing a more constructive frame of mind on this dispute. Possibly a military conflict in the South China Sea might focus minds on the need to really resolve this dispute. Or perhaps a very steep rise in energy resources could have the same outcome. Okay, heading for the rocks. That's my worst case scenario. In it, I posit that the South China Sea becomes embroiled in the geostrategic rivalry between the United States and China. Currently, the relationship between China and the United States is fundamentally stable, but there are mutual misperceptions and numerous bilateral problems. And I think there's a feeling in both Washington and Beijing that the two countries are drifting towards overt strategic rivalry, and I think that's one of the reasons that Xi Jinping and President Obama held their summit in California earlier this year, was to try to arrest that drift. The South China Sea has become a point of contention between the two countries. The United States, without directly naming China, has essentially accused China of coercion and bullying to advance its territorial claims. China, on the other hand, has accused the United States of meddling in the dispute, of exaggerating tensions and threats to freedom of navigation in order to, as a pretext to return to Asia. and of using Vietnam and the Philippines as proxies in this dispute. There are also very significant differences in approach between Washington and Beijing on how to manage and resolve the dispute. The United States, like ASEAN, wants to see an early conclusion to a code of conduct. China does not share this sense of urgency, as we've heard. The United States advocates a multilateral solution to the dispute, but China prefers a bilateral approach. The United States has indirectly voiced support for the Philippines' legal submission to the UN, but China has rejected it. And of course, the two countries disagree over whether military activities in the EEZ of a coastal state are illegal or not. So the South China Sea is currently a point of contention between the United States and China, but of course it's not a major one. And the risk of a US-China naval clash in the South China Sea, I would say, is very low. However, if negative trends in Sino-US relations strengthen, then I think almost certainly the South China Sea dispute will become more complicated and more fractious. An obvious victim of that would be ASEAN unity, again, which we've heard a lot of in the last 2 days. ASEAN unity has come under strain in recent years, and ASEAN leaders themselves have articulated a concern that if the relationship between the United States and China becomes more competitive or more confrontational, then the existing divisions within the organizations will widen and derail ASEAN's aspirations for centrality in the regional security architecture building process. I think if the South China Sea dispute does start to head towards the rocks, then ASEAN could quickly fade into irrelevance. A shipwreck is my very, very worst case scenario. That is to say, China moves to resolve the dispute through military force. Now, apart from the statements from a few retired PLA generals and the odd headline in the Global Times, I agree with our Chinese speaker in the last panel that the majority of Chinese analysts and policymakers do not support this course of action on the sensible grounds that the costs would far outweigh the benefits. But of course, that calculation could change over time. And China may feel in the future that as its relationship with the United States deteriorates, that it may want to physically dominate the South China Sea in order to protect its southern flank. China's involvement in the 3 Indo-Chinese wars from 1949 to 1989 was predicated on exactly the same strategic rationale. In conclusion then, I think the next 10 years will be a crucial phase in the long-running saga of the South China Sea dispute. If the claimants design and implement an effective set of conflict prevention and crisis management mechanisms, provide legal clarity to their claims, and finally muster the political will to pursue a negotiated settlement that resolves the sovereignty question and divides maritime resources in an equitable manner, then the future is a bright one. But if the status quo continues and tensions are allowed to fester, the dispute will, I think, almost certainly be sucked into the vortex of US-China rivalry, rendering it utterly intractable for at least several more generations. And on that rather bleak note, I will end my presentation. Thank you.
Thank you, Ian. Now I think we have another, hopefully, half an hour for discussion. And I hope that the commentary from the floor would be made as short as possible so that we'll give some time for the panelists to respond to. Yeah, I start from here. Marx, and then that one. Yeah.
Yes, thank you, Mr. Chairman. I just have a quick comment on Dr. Tran's paper, which was an excellent paper with a lot of thought, but in the end it showed the mark of a lawyer, and it's true. that the other claimants and indeed the whole situation is riding on the back of the Philippines right now. But it's not really the legal outcome of this arbitration that is going to determine whether any other country might try this route or whether there will be continued peace and stability in the South China Sea. It's going to be the political effect of that outcome. So it's a few steps down the road, no matter what the outcome is, countries are going to wait and see what the effects are. So I'm just throwing in, I'm going back to my paper in the beginning session, that it's the political effects of the arbitration and not the legal outcome itself.
Thank you. And the gentleman over there, please.
Yes, I have two questions. The first one to my friend JIANWEI. I'm intrigued by his observation that the Philippines might not be interested in extending the scope of the COC to the Scarborough Shoal. How do you respond to that? And the second question is to direct to Ms. Lee. Thank you for a very interesting paper. You alluded in your presentation to the 2011 agreement between China and Vietnam. And I understand that in that agreement, China and Vietnam agree that for those disputes involving a third party, the two countries will consult that third party. Do you think that that should be the basis for China and to reconcile the two approaches that currently have in the bilateral relations with Vietnam and the Philippines respectively? Thank you very much.
Thank you. And the gentleman over there.
I have a question to Mr. Velasco. The question is about the Philippines' obligation to exchange views under UNCLOS. In relation to the issue of features under Article 121 in the Philippine-China arbitration, when did the Philippines and China exchange the views about the new disputes, such as whether Scarborough Shoal is an island or a rock? Could you please show us the details and the evidence? Thank you.
Thank you. Just a question for Ian. I like the idea of scenarios. And just one question, because your last scenario for a shipwreck is premised on worsening relations between China and the United States in their rivalry. But what would be the scenario if U.S.-China relations actually improve and there is even closer partnership between the two, considering their economic relations? Thank you.
Yeah, thank you, Mr. Chairman. Just one very brief question to Mr. Velasco. I had already asked this question to many of my Philippine friends. Is the treaty limits still existed in the Philippine claim in the law of the sea? Thank you.
Yeah, Temsak.
Thank you, Pak HASJIM. I have a question for all the panelists. What is the current policy position of coastal state concerning military activities of foreign ships and foreign aircraft? I think Pak HASJIM, you can also enlighten us on Indonesia policy on this issue. And for Dr. Ian's story, is it true that at the latest Shangri-La dialogue, China indicated that it can accept foreign military activity in the EEZ because it's going to do the same in Guam and Hawaii?
Thank you. I have two questions. One for Dr. Tran. I was very interested in your intricate proposal for the Code of Conduct. And you mentioned in your presentation that it could be made less legally binding rather than a binding Code of Conduct. And my immediate question is, if it is made less legally binding, how do you distinguish a Code of Conduct from the DOC, which we discovered earlier. You can add additional functions which will not be legally binding, they'll be simply declaratory, in which case you merely have an extended DOC. The second question is to Ian Storey. While welcoming his, what I call, illusion-free presentation, I pick up on one point, and I'm not persuaded that China's 9-dash line is really the crux of the matter. It could be regarded as an impediment, and for some Chinese lawyers, even an embarrassment. It's a product of an earlier age, and even if you remove the 9-dash line, the claim would still remain. So I think the crux lies elsewhere.
Thank you.
Then it's me.
Thank
you.
Yes, please.
I have a question to Li Jianwei, because I found your comparison of China's relations with Vietnam and with the Philippines very interesting. And you are asking, why did one of these relationships develop so much better than the other or worse than the other? And your answer is that there are formal mechanisms of crisis management agreed between Vietnam and China, but not between China and the Philippines. There could be other differences also in those relationships, like that the Vietnam and China are led by the same kind of political party, and that the Philippines has an alliance with the United States. But there is also another difference, which is that in the area between the Philippines and China, there is also Taiwan. So in a way, you get the Taiwan issue also getting into that corner of the South China Sea. And in that connection, I wonder if I could ask you, Li Jianwei, since researchers have the task, one of their tasks is to come up with constructive ideas for their governments. Would it be an idea for China to invite Taiwan as a fishing entity into a fishing agreement with the Philippines concerning Scarborough Shoal's 12 nautical mile territorial sea, and then have a kind of trilateral fishing management regime for just that area? This also as a way of preempting a decision by the arbitral tribunal on that point in the Philippine submission. Thank you.
Ralph.
Very quick question to Ian. I very much enjoyed your presentation. I don't know whether you're a gambler or not, but if you were, where would you put your money? Which is the most likely scenario in your view, and why?
Thank you. I have a question for Ian. Ian, you raised a number of game-changing scenarios, but it struck me that you didn't directly address what the consequences would be if the Annex 7 tribunal ruled that it had jurisdiction and then came down with a decision that substantially favoured the Philippines' position.
Thank you very much. So many questions here. We may stay until tomorrow morning here, I suppose. But let me ask the panelists to answer as clear and as short as possible. Please. We start with, from that end, Ian. Please, thank you.
Okay. Take the questions in order. To Jay, frankly, I hadn't really considered a situation in which the relationship between China and the United States got better. I was basing all of my that particular scenario, the last one, on present trends, extrapolating present trends. But I guess if, by the logic of my paper, if the relationship between Washington and Beijing improved, then that would favor the second scenario, the plain sailing, in which the issue became much less contentious and much less politicized, and perhaps the claimants could then, that might clear the way for the claimants to move forward with conflict management and conflict resolution. Termsak's question on military activities in the EEZ of coastal states, I'd have to defer to the immense legal expertise which is in this room, including Ambassador HASJIM Jalal, Bob Beckman, I don't know if he's here, and a few others. My understanding is that roughly 22 countries in the world take the same position as China, that military activities are illegal, including some Asian states. I think Malaysia is one. I think Thailand is I definitely think that Thailand is another. China, India. Japan is interesting. It's never actually stated what its position is on this. I think it generally supports the American view that it is legal, but it doesn't want to say that because that would seem to justify Chinese activities in its EEZ. And that brings me to your question on the Shangri-La dialogue. I wasn't there. I read about it in the press. Apparently one of the Chinese delegates said that China was conducting military surveillance activities off the coast of Hawaii and somewhere else, or at least military activities. They didn't specify surveillance, but one can assume it was or included surveillance. I think that's to be welcomed. It means that China is following the norms of most other countries in the world. And of course, I think if you speak to any senior Japanese policymaker, he or she will tell you that China has been doing this in their EEZ for a very long time anyway. Leszek Brzezinski's question on the 9-dash line is the crux of the problem. I can only repeat what I said in my presentation. I think it does stand in the way of not only joint development but a resolution of the dispute because it's so ambiguous and it slows down negotiations on a whole range of issues. Ralph, as you know, I'm not a betting man, but I'm willing to put every single penny I have on status quo for the foreseeable future, followed by one of the other two scenarios. As for Don, the Philippine submission, it's possible that as early as this time next year, the arbitral tribunal will issue an award, and it will be very interesting to see what that award will be. If it does essentially rule in favor of the Philippines, then I think that is a legal and a moral victory for the Philippines. And it will increase pressure on China to clarify what it is claiming and to justify those claims under international law. My guess is that because China sees that the Permanent Court of Arbitration does not have jurisdiction over this case, that it will simply ignore the ruling and it won't really have a dramatic impact on how the dispute develops.
Thank you very much, Ian. But let me just comment a little bit also on these military activities in the economic zone. Immediately after the EP3 incident in the South China Sea some 10 years ago or so, we organized a meeting, first in Bali, then in Shanghai, then in Tokyo, then in Honolulu, then in Tokyo again, trying to find out what kind of guidelines that we could suggest on this military exercise in the economic zone of other countries. And I should refer to Max Valencia, who drafted the paper together with the others at the time. And, but my understanding was, please correct me, Max, that paper, that guidelines was submitted by the OPRF, Ocean Policy Research Foundation of Japan, to the United Nations, but I understand the United States objected to it. And consequently, the idea died. And then the guidelines got stuck somewhere in the drawer, never come up again. And at that time, you know, after that kind of meetings, issue came up all the time. But at one of the meetings recently, I understand that some people like to review again. Otherwise, we will see a lot of situations like that in the South China Sea area, where military exercises are carried out, but the coastal countries may find it out that it endangers their own security as well. So that I think what I can understand. But please, Dr. Tui.
Thank you. I have 3 questions, but I think I can continue with the issue military activity in EG first, because I attended a conference just last month in Tokyo, organized again by Ocean Policy Research Foundation, to modify the guidelines that they adopted before to accommodate, I think mainly to accommodate the US. And the main content of this new documents is that they are accepting for military activity within EZ. And interestingly, there was China participant, Nong Hong, of course. Nong Hong participated in this conference also. And I think here is the balance and the issue between sovereignty rights and jurisdiction of coastal states vis-a-vis freedom of and rights of user states within EZ. And as Jan's story mentioned, there are different views on this issue. But for the South China Sea issue, there are two aspects of this issue. First is whether one country can conduct military activity in recognized EZ. And second issue is whether countries can conduct military activity in disputed EZ. So, frankly, my observation is that if Vietnam opposes military activity of major powers, we cannot use UNCLOS to prevent so-called China from acting like that, because China will apply the argument of EZ for partial and partly to conduct military activity in our own EZ. So here we have a new law of the sea. Within that law, Vietnam will follow what is written in UNCLOS, of course. And a specific question to me on legal efforts of arbitration from Max. Just in my presentation, I also predict the the political efforts of arbitration towards the COC consultation or formulation. And of course, you know, the awards by arbitration at least legally equally to an agreement on the COC, because China already ratified the UNCLOS, right? So the awards win by toward China, and from legal aspect is efforts towards China, and of course from Philippines notification to the arbitration, they ask China to withdraw the NIDAS line and stop activities that affect Philippines' rights within its own EZ. So the main issue of COC should be the element of what action the country can do in the disputed EZ or claim EZ. So it's the same content of arbitration awards and the COC. So if the arbitration will rule in favor of Philippines, other country, of course, they will wait and see. And legal awards will affect political calculation. And whenever they see they can bring China to the court to protect their interest, and they can win, they will put more calculation on this channel. And the third question from Leszek Buzinski about the balance between a less legally binding declaration and more legally binding agreement of the COC. Here, I think it's not an issue of binding or non-binding, but the main issue is the contents of the documents. So far, until now, China, we have to recognize that China did not clearly violate the provision that clearly written in the DOC. For example, no inhabit on non-occupied islands, no use of force. But here the issue is with some ambiguous provision regarding what action can be categorized as complicated or affects the peace and stability in the region. So country blame each other for this ambiguous provision, because of this ambiguous provision. So the main issue here is more elements, more specific provision is better than a less legally binding but non-specific provision. Thank you.
Thank you. And Lee?
Thank you for the comments and questions from the floor. I think there are altogether 3 questions, either directly addressed to me or also addressed to me indirectly. And the first question, I'm not quite sure from whom, but I think, since I'm listening during the past 2 days very carefully, although I couldn't see clearly, I guess it's from Dr. Dung, right? First question about the joint communique in 2011 signed between China and Vietnam. It mentioned disputes involving other countries should consult other parties, right? I agree. Yes, it is in it, but my paper is mainly dealing with the bilateral issue, like how these two bilateral relations dealing with their South China Sea issue. Maybe I need another paper to deal with another, the topic you mentioned. The second question is about military activities in coastal states' attitude towards military activities in the EEZ. Just now, Ambassador JIANWEI has gave a brief background on these discussions from academic and practitioners in the past. And from my observation, the Chinese attitudes towards military activities in EEZ is that China is against military activities which has the nature of intrusive. That can be shown in the 2 incidents. One is an EP3 incident in 2001, and also impeccable incident in 2009. And the third question is Stein, from Stein, I think. Yeah. Are there, like other factors may affect the difference between China and Vietnam and China Philippines, such as the involvement of the other parties, like parties outside of the region, like the U.S. I agree. In my paper, I showed the disputes and the difference in their management approach, and also what are the factors affecting their different approaches. I agree with you that other factors should take into consideration. And in regard to whether involve Taiwan, involve Taiwan as a fishing entity in the agreement, in agreement on the issues of fishing, I think all the parties of which they have interest in the issues should be considered. And also, my institute organized a cross-strait workshop, a series of cross-strait workshop, and on that workshop, Taiwan and mainland China, they discuss issues including the issue of fishing, how that could be attacked. I also think in the series workshop on managing potential conflicts in the South China Sea, hosted by Indonesia, this topic also discussed. Thank you.
Thank you. Mr. VELASCO.
Thank you, Mr. Chair. Thank you for the questions, and I have 3 questions to answer. The first one pertains to the COC, whether it should extend to Scarborough Shoal. It would be too early to tell now what areas would be covered by the COC if ever we get to that point of negotiating the COC. But one thing is, I think from the point of view of the Philippines have every interest to have a binding code of conduct. If we go by history of the DOC, Philippines was one of those who are very adamant to have a binding code of conduct. Why? Well, the year before the negotiation started, there was the mischief reef. China occupied the mischief reef. So we wanted a binding code of conduct that would govern the conduct of the parties in the South China Sea. But then other parties didn't want a binding code of conduct. So that's why it was just reduced to a non-binding declaration of conduct. So if we are to negotiate a new COC, I would go back to my presentation. We have to have clarity of the legal positions. And if I am allowed to go back again to my example, peace negotiations, if the parties know what they want, then they can start negotiating. If the rebel wants independence and the mother country wants for them to retain, then we know where to start. But then if the parties don't know what they want and what they want to impose on the other, then negotiation wouldn't go anywhere. So it's the same with the code of conduct. If the parties are clear on their legal positions, then we can start and talk about what would be the scope, for example, of code of conduct. And I think it's worth noting what Ian Storey said about the COC. Correct me if I'm wrong, that it could be a process-driven rather than result-driven, which brings back to my presentation. What is our intention in going to negotiations? Do you want to end the conflict? If so, that should be the main purpose of having a COC. But if that is not the main purpose of having a COC, then in the broad sense of the term, a COC would just be another confidence-building measure. And a confidence-building measure cannot have cannot have its end another confidence-building measure. And that's what I would call a teleological absurdity. It could be meaningful only if the purpose of your COC is to resolve the conflict. On the second question, I didn't get it clearly, but I understand that it's about the territorial occupation by the Philippines. And we're going into territorial dispute. And just like any other dispute, it has to be resolved peacefully and in accordance with international law. What I could say is that we should abide by what the UN Charter says, that nobody should be allowed to use force. And if somebody occupies a territory by means of force, then that's against international law. And this I can tell you, the features occupied by the Philippines were not occupied through force, and our rights there in those features are in accordance with international law. Now, we shouldn't be going to details because, of course, this is very contentious issue, but that's just the explanation to that. As to the third question regarding the treaty limits, I suppose you're referring to the 1898 Treaty of Paris. Well, in the South China Sea or in any dispute on territorial and maritime claims, there are two types of claims, right? The territorial rights and maritime entitlements. So with regard to the maritime entitlements, the Treaty of Paris, if we are to use that as your, for example, base points for projecting your maritime entitlements, that is not in accordance with what the UNCLOS says. So what the Philippines did was, because Philippines is rallying behind the banner rule of law, so it has to walk the talk, and it had to align its laws in accordance with UNCLOS. That's why we passed the Archipelagic Baselines Act, which is really drawing the baselines in accordance with international law, with UNCLOS, and project from those baselines the maritime entitlements under UNCLOS. So, insofar as maritime entitlements are concerned, the Treaty of Paris has been superseded by the archipelagic baselines, but the Treaty of Paris remains a source of right with respect to territorial claims. Thank you.
Thank you. And I think we ends up there. There may be some more comments, but the time I think is limiting and therefore I think I shall. Yeah, and then I was given another 5 minutes to move on. Yeah. I think if I were to ask questions, can I understand that the China-Philippines Code of Conduct in 1995 is now moribund, is now dead? Because there have been some code of conduct between China and the Philippines, as I remember, in 1995. Is it dead already?
During the process of the Scarborough Shoal, I don't see that code of conduct, which signed in August 1995, has been used. So you can guess what's the meaning of that.
So in other words, it is moribund. It is not effective anymore. That's it, yeah.
Yeah, that's my understanding. It's not effectively used.
Yeah. The other thing is, in the workshop some 10, 15 years ago, we talked about the, what I call is the efforts to calm down the situation, like not to occupy new features. But apparently now that's also moribund. That's also no longer being followed, although at that time we did discuss and we did agree on that one. Is it correct? Am I correct to say that the agreement or understanding that we have not to occupy new features in the South China Sea is not followed anymore? Please.
I think that depends on how you define occupation. I think from the Philippine perspective, they would see that China's activities at Scarborough Shoal last year is an effective occupation of Scarborough Shoal. But I'm sure the Chinese side would be that no, we have not constructed any facilities on Scarborough Shoal, and therefore we have not contravened the DOC.
If we read clearly, the DOC it did not say that the country cannot make new occupation. They just say country cannot inhabit in uninhabited land, rocks and islands there. It means countries cannot send people to unoccupied rocks or islands there. And I think China is very clever in apply this provision to Scarborough Shoal. They established effective occupation without sending people on the rocks.
This question. We need to have some lawyers to look at this question.
Okay. Thank you. You have any more comments?
Well, the only thing I can say is that since 2002, since the Declaration of Conduct, the Philippines has not occupied any feature. So, insofar as the Philippines is concerned, it has complied with the provision of the DOC.
Do you have any comment?
For my understanding, I should say after the DOC was signed, there are still some unilateral actions going on. I don't feel that the principles of DOC are fully abided by all the parties.
Thank you very much. I think we have spent the time so fruitfully in the discussion, and I hope it is very useful to all of us. Thank you. Let's give applause to all our